and Pakistan relating to the boundary of Kutch. To solve this dispute, Security Council appointed the mediator, and the mediator, as you can see from the slide, the Soviet Premier Kosygin was appointed in the year of 1966. Through the mediation, the whole dispute relating to the boundary of Kutch, territory of Kutch, was solved by this mediator, successfully done and happily done by both the disputing states, India and Pakistan. So, in mediation and in good offices, there are few points of differences. Let me tell you the difference between good offices and mediation. Good offices includes almost 3 parties or third party is involved in good offices. In mediation, third party is involved. It will take part in the discussion. In good offices, third party will not take part in discussion. The next point which differs from good offices to mediation is, in mediation, this third party will suggest the proposals to settle the dispute. In mediation, as third party is not taking part in the discussion, there is no need or there is no space for suggestions from that third party. So this is the second available method for settlement of dispute. Now we will go to the third available method for settlement of dispute. This third method is of conciliation. What is the meaning of conciliation? When any dispute is referred to a commission or a committee, it is called dispute is solved through conciliation. The second characteristic of conciliation is commission investigates on the basis of the dispute, which means commission is investigating not only the fact but also the base of the dispute, which says whether it is a legal or a political kind of dispute. The fourth characteristic of conciliation is, after investigating the fact of the case or of the dispute, the commission will make a report containing proposals for settlement. And the last characteristic is, these proposals are not binding the state. Now the fourth characteristic is the important one, due to which conciliation differs from arbitration. First, conciliation involves committee or commission or a group of persons to be appointed by the disputant parties themselves, and they are referred to solve the dispute. This committee or a commission, when they will investigate the base of the dispute, through their investigation, they will ascertain the fact. They will investigate. Investigation includes cross-examination, arguments, inquiry. Everything is covered in case of conciliation. So, after investigating the fact, the commission or a committee or the body of a person will prepare the report of their ascertainment. This report will also contain proposal for settlement of dispute. The word used is proposal. So, proposals can be accepted, cannot be accepted. And as this whole procedure of conciliation is not the judicial, It is covered by extrajudicial methods, so it is not having that binding effect. This fourth characteristic, that proposals of conciliator is not binding to the disputant states. It differs from the arbitral tribunal, whereas award is binding to all the disputant parties. There the word used is award, not the proposal. So in conciliation, it includes investigation, then it includes the procedure to prepare report, it also includes the proposals, and the fourth one is it is not binding. Now, how conciliation differs from good office's mediation? Conciliation also involves third party involvement, right? Because conciliator is the third person. As third party is involved, how will it differ from mediation? Friends, in mediation or good offices, there is no scope for investigation. So, on the point of investigation, it differs from mediation. Second, in mediation, if the proposal is accepted, then mediator will play the role of guarantor in any kind of agreement or a treaty. In conciliation, the conciliator, if proposes any kind of proposals or suggestions and accepted, then the agreement will be carried out on the basis of the proposals. There, conciliator is not considered as the guarantor for the settlement of dispute. So friend, this is the third method available for peaceful settlement of dispute. Now let's go to the fourth one. From this slide, you can see that through inquiry also, two states can solve the dispute amicably, peacefully, Shanti-purvak. The inquiry includes four main ingredients. First one is commission is appointed to ascertain the facts of the dispute, which is similar as in case of conciliation. The second, where the procedure of inquiry for the settlement of dispute was evolved at the Hague Conference of 1899. It is not at the liberty of the disputant state to start inquiry in their own manner. No, if you are trying to settle the dispute through inquiry, it must be follow the procedure prescribed under Hague Conference of 1899. The third important point regarding inquiry is available to the states which are not willing to submit their disputes to an agreement. See friends, if disputant states are ready to solve their dispute through the available methods, which may be conciliation, may be good offices or mediation or negotiation. If all these three methods are not agreeable to the disputant states, then they can go for the fourth method of inquiry. For that, they must enter into the agreement, and if the agreement is present, then they can solve the dispute through inquiry. The next slide says, inquiry is constituted by special agreement between parties in dispute. As I said, that if agreement is not there, is not present before arising of the dispute, then the special agreement will be constituted by the disputant state. This special agreement will provide for the place where the commission will sit and the language which the commission will use. Friends, it is the international law. It is not compulsory to follow the language as declared by the United Nations of organization. All the different member states are having their own national language. As per our India, it is Rashtra Bhasha Hindi. It may be different in other states. So, in inquiry, if you are going to solve the dispute through inquiry and if the agreement is not available at the time of dispute, you can enter into the new agreement, which new agreement is called as per the international law the special agreement. In this special agreement, which came into force after the dispute, it will say the place where the commission will sit and will try for settlement of dispute and which language will be used for this settlement. If two states are agreed to use non-English language, they must cite this language in that special agreement. So friends, inquiry also include the interference of third party. But for this kind of help, they must have either a treaty before the arising of the dispute, or if after arising of dispute, they must enter into the special agreement. The next method available for the settlement of dispute is by the United Nations. Article number 2, para 3 of the Statute of United Nations Organization says all members shall settle their international disputes by peaceful means. So, Charter itself provides the peaceful methods to settle the dispute, and the Article 33 enumerates different methods for peaceful settlement of dispute between states, which we are discussing, which are negotiation, conciliation, mediation, inquiry, etc. These two organs, the main two organs of United Nations, General Assembly and Security Council, also work for the settlement of dispute. General Assembly, though, is not authorized to solve the dispute, but as per Article 11 of the Charter says that the General Assembly may discuss the dispute in it. So, General Assembly can start discussion for settlement of dispute, and under Article 14 of the Charter, General Assembly may make recommendations to the disputant parties. To render this duty through its resolution, General Assembly has passed number of declarations to encourage the peaceful means for settlement of disputes. Manila Declaration, Declaration on Prevention and Removal of Disputes, Handbook on Peaceful Settlement of Disputes. These are the main declarations on which General Assembly has started the discussion, and through its discussion it has solved the dispute. The next available method is the steps taken by the Security Council. Security Council can entertain only those disputes which are likely to endanger the international peace and security. So, if any dispute which is not dangerous to the international peace and security, Security Council is not available. If the member states or non-member states are trying to solve their dispute through Security Council, they must file an application to Security Council, and the non-member state or member state can bring dispute by this kind of application through Security Council. And the second method available for peaceful settlement is judicial settlement of dispute. When the dispute is referred to the International Court of Justice or to the arbitral tribunal, it is said that dispute is solved through the judicial settlement of dispute. This judicial settlement, when is carried out by International Court of Justice, the source used by settlement is called the International Court of Justice. This International Court of Justice was in force from the year of 1922. From 22 to 1945, it was working as Permanent Court of Justice under the League of Nations, and after Second World War it was dissolved and again constituted after 1945 as International Court of Justice. This Permanent Court of Justice delivered 29 continuous cases through 1922 to 1945, and it gave a very legal opinion in 22 disputes or incidents where the opinions of Permanent Court of Justice considered to solve the dispute by judicial means. After Second World War, the Permanent Court of Justice was dissolved and International Court of Justice was established by the Charter of United Nations of Organization. United Nations of Organization came in force in the year of 1946. So,